Welcome to Copyright Fact or Fiction, a presentation by your copyright fellows Taylor Ferris and Corinne Fombelle. As copyright fellows at the CAI, we've had to learn the basics of copyright law and learn that a lot of our preconceived notions of copyright were wrong or lacked nuance. Copyright law is often mentioned but rarely understood, with many people unaware of its quirks and fewer unaware of the ever-changing landscape that copyright exists in. As such, we wanted to impart a few of those most common copyright fictions and dispel those myths. The first section of this presentation covers copyrightability, the basics of what is covered under copyright law. The first fiction is that all copyrighted works are marked with the copyright symbol. You may think that if there's no little C at the bottom of a work, you're free to use it, or you can't get into trouble if there's no notice. The reality is that copyright is automatically applied to any work as soon as it is fixed. Fixed in this case means written down, or, in the case of audio or visual works, recorded. No notice is required, but it is recommended that if you give a notice, you utilize the format indicated on the slide. Creators may do this to make clear who holds the copyright, which may make it easier for individuals to ask the copyright holder for permission to use the work if they so choose. The next fiction we wanted to discuss is that discoveries are covered by copyright. You may believe that the T-Rex at the Museum of Natural History in New York City is covered by copyright, or that the video your cat took of itself while your phone was out is owned by you. This isn't true. In fact, only human-created works are protected by copyright. Discoveries such as fossils or other natural objects are not creative enough, nor are there human authors that could claim copyright. There was actually a recent case about this in which a monkey, Naruto, took a selfie and the owner of the camera wanted to claim copyright. The courts found that neither the camera owner nor the monkey held ownership of the photo, as the creator was not a human. This may seem like a silly case, but it has many implications going forward in fields such as AI. The next myth we wanted to talk about is that titles or names are copyrightable. You may think, I can't reference this book or movie title because of copyright law, or that using someone's name infringes on their copyright. This isn't actually true because copyright requires sufficient creativity. A snippet as short as a title or a character name does not contain the required creative spark for copyright protection, but you still want to be careful about this because although copyright law does not protect this kind of expression, it still might be protected by trademark law, which is a little different. The next thing we wanted to talk about is this idea that only professionals have copyrights. You may think fancy books, movies, and art earn copyright, but not just regular people's work, or that I have to do something extraordinary to gain copyright protection. Thankfully, this isn't true. In fact, anyone's works are copyrightable. Again, copyright is an automatic process, so as soon as that expressive work is fixed, that work is protected. There's no special level of expertise or high-quality artistic merit that's required. It can be bad art, and it's still going to be protected. Registration does get additional benefits, such as the right to sue, but this is by no means mandatory. In a similar vein, you may think that only artistic works can merit copyright protection. This is also not true, and many forms of expression are copyrightable. Again, anyone can make a copyrightable work, and you don't have to be a professional artist, writer, or musician. Even software code is copyrightable. However, facts and data are not copyrightable because they're not creative enough and belong to the public for the promotion of progress and knowledge.
Our last fiction regarding copyrightability is that copyright protects ideas. Someone may say, you shouldn't steal my idea, it's protected by copyright. Or, I can't write a story with a plot similar to an existing plot. In fact, copyright only protects expression. Only the creative expression embodied in a fixed work, such as a book or a recorded song, is protected by copyright. That means that the specific words and notes on the page or in the recording or on the art or sculpture are what counts. There's no protection for the underlying ideas, such as the type of character or the basic plot or genre, such as a Romeo and Juliet story. Those are not protected. Next, we'll be discussing a few facts and fictions regarding use. The first fiction is that you only need to give credit under copyright law to comply. You may put a disclaimer that says, I do not own this material, or you may think, I gave the author credit, so I'm not breaking copyright law. In fact, permission is required, unless another exemption applies. Simply crediting the author does not constitute permission, and putting a disclaimer on a work that is not yours, or on a work that you created that utilizes other works you do not own, holds no legal weight. In order to use copyrighted material, you must either ask permission from the author and receive a yes, or determine that your use is a fair use or another statutory exemption that may apply. Next, people may believe that less than 10% is a fair use because they see fair use as a black and white doctrine. They may say things like, I can definitely always take a small amount from a copyrighted work, or I definitely cannot use an entire copyrighted work fairly. These are both wrong because, in fact, fair use is a 4-factor analysis that varies from situation to situation. In different cases, courts have found that using only a little bit of a work still might be copyright infringement, or using an entire copyrighted work within your own work might still be a fair use. There are 4 statutory factors that users and courts can examine to determine whether or not the use is fair. First, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. The second is the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for or value of the copyrighted work. So courts, in an infringement case, will look at these 4 factors and weigh them holistically in determining whether the use is fair. And a user can use these same factors beforehand to determine whether or not they should use the work. Final fiction is that anything on the internet is fair game. You may believe if I found it online, I can reuse it however I want. Or, as long as I attribute, I'm not infringing the copyright of this picture I found. As you've probably learned from this presentation so far, copyright is nuanced and very situation dependent. So, a random picture found on the internet could have copyright protection, or it could be dedicated to the public domain. It may even have a license that you can comply with. For example, Creative Commons licenses are options that exist that have certain rules to follow, such as attribution or non-commercial use, but they still give much more freedom to someone who wants to use the image or work with more certainty and without fear of copyright law. Additionally, some copyrights may have expired on things you found on the internet, or the work may be in the public domain for other reasons, such as being a work of the federal government. So there are many different options that you may have to think about when you're looking at things from the internet. So just to wrap up some of the things we've talked about so far, copyright protects anyone's creative expression regardless of notice or skill. And additionally, fair use is a right that allows flexibility in copyright law, but it is not a free-for-all. We hope you've enjoyed this presentation, and thank you so much for listening.